I'm going to talk about the role of regulation in EU competition law assessment. EU law is a particularly fruitful vehicle by which to explore the interrelationship between competition law and regulation when competition law is concurrently applied in regulated markets. This is because the pre-existence of sector-specific regulation does not, unless exceptionally, oust the jurisdiction of Articles 101 or 102. 101 and 102 are primary treaty rules. They continue to take precedence over any conflicting secondary legislation or national legislation. So undertakings are expected to comply with both sets of legal requirements. And indeed, competition law and regulation have been conceptualized as two freestanding, distinct barriers to lawful market participation by economic operators. Each imposes distinct requirements and each is enforced by different regulators. This two barriers analogy does not necessarily see competition law and sector-specific regulation as traversing the same substantive ground or as being mutually reinforcing, but nor does it provide us with a huge amount of guidance as to what we should do if these requirements come into conflict, which, as we shall see, can indeed happen in practice. Before we talk about the concurrent application of competition law, it's worth considering briefly why we might want to apply competition law in regulated markets, because the pre-existence of sector-specific regulation presupposes that a regulator or legislator has considered how best to structure effective competition within a market. And we might ask why we need or want to fine-tune that regulatory settlement through the application of competition law. Most basically, it's about a need to ensure the effectiveness of competition law supervision. Regulated markets are really the rule rather than the exception today. If we are too eager and willing to oust the jurisdiction of competition law by the mere presence of regulation, well, that's going to have very negative impacts in terms of the substantive scope and reach of competition law in practice. It's also about securing the benefits of regulatory complementarity. The two barriers idea tells us that regulation and competition law often seek to achieve contrasting, usually complementary, but not always socially valuable objectives. They use different mechanisms to do so. And if we can have a balance of competition law and regulation within a market, well, then we can best secure the most effective, most nuanced regulatory toolbox to make sure that markets are working well for consumers in future. There are some risks, however, associated with concurrent application. First, the prior existence of regulation might be quite a disruptive presence within competition law analysis. It might change the balance, the calculus of considerations within our ordinary competition law assessment tools. It's necessary to be very clear about the impact of regulation, to take it into account in competition law assessment so that we are actually confident that applying competition law is making a market work better in practice. Second, there's a risk of unfairness to defendants. First, because the impact of regulation might be such in a market that it's actually difficult to conclude that there's any culpability on the part of the undertaking concerned. So we might be finding liability without any actual wrongfulness. On the other hand, it might be quite clear that the defendant has acted in quite a reprehensible manner in the market, but it has already been punished under a parallel regulatory enforcement regime. And EU competition law actually is quite a narrow principle of the nobis in idem idea. So there's quite a lot of scope for multiple prosecutions of the same behavior from different regulatory perspectives. And third, there's an institutional risk. Occasionally, concurrent application cases disclose not really a concern with bad behavior on the part of the defendant undertaking, but rather a jostling for jurisdiction amongst regulators. And sometimes the fact that the competition enforcer really thinks that the regulator got the answer wrong in the market concerned. And I think we should be quite wary, for reasons I'll discuss later, of applying competition law in such circumstances. I'm going to suggest three different perspectives for looking at or trying to take account of the impact of regulation within competition law analysis. The first, most basic, and the one that really applies in all circumstances, is the fact that regulation functions as an element of the legal and economic context to suspect behavior under both Articles 101 and 102. The contemporary competition rules require a context-specific assessment of alleged restraints, of which, of course, the underlying regulatory framework is an integral part. On the slide, you have a quote from the recent Budapest Banks case, where the court emphasized that when considering potentially restrictive coordination contrary to Article 101, you need to take into account the legal and economic context of the restraint, as well as the real conditions of the functioning and structure of the market or markets in question, of which, of course, the underlying regulatory framework is likely to play quite an important role. And you find similar statements in recent Article 102 cases. What does this mean in practice? Well, on the one hand, sector-specific regulation might function to remove behavior from the scope of competition law entirely. This might be because the regulation imposes obligations or powers on the entity, which mean that it falls outside the definition of an undertaking if it's acting on the basis of solidarity, or really more as a public regulator than as an economic operator. The regulation might remove all scope for competition within a market and thus all scope for potentially anti-competitive behavior. Or the regulation might have such an impact on the defendant's behavior that it's not really possible to say that the anti-competitive conduct is attributable to autonomous decision-making by that undertaking, but rather is a result of state action. And again, the state action defense is likely to kick in there. On the other hand, sector-specific regulation might augment a finding of breach. It could assist in finding a position of dominance to begin with, particularly if the defendant has been granted special or exclusive rights under the legislation. It might heighten the special responsibility of a dominant firm to protect the competitive process in the way it operates in the market. Or it might provide a plausible anti-competitive rationale for more ambiguous behavior if what the undertaking is doing is really trying to escape some of the constraints that have been imposed on it by the regulatory structure. It is not, importantly, a defense to finding of liability that the regulation either encourages or facilitates the breach if it does not outright compel the breach. But it may merit a reduction in fine to essentially reflect the lower level of culpability involved. Secondly, regulation might be considered to set the boundaries of competition on the merits, in particular where a regulatory standard is imported as essentially the standard for antitrust liability in the circumstances. This idea emerges from a recent strand of case law, most of which relates to forms of refusal to deal. So circumstances where an undertaking has either explicitly or constructively refused to grant access to its infrastructure. Typically, there's quite a demanding test in EU law. You need to show indispensability under the Bronner case. But in this emerging strand of case law, the court has been prepared to say that the regulatory duty to deal can be treated as equivalent, can be used as a proxy for satisfying the antitrust standard to demonstrate an antitrust duty to deal. Why might the court do this? Well, of course, it's quite a pragmatic approach. You could argue that competition on the merits presumes lawful behavior and thus compliance with any relevant regulatory standards. There is, however, a question not really addressed by the court as to why a regulatory duty, which has potentially been imposed for reasons that are far removed from the ideals of competition policy, should be taken to delimit the scope of antitrust liability. And there's also potentially a risk of almost limitless liability for dominant firms, where mere non-compliance with any regulatory requirement comes to be conceptualized as a potential abuse. And this is a concern emerging from the ongoing German Facebook case. Here, the dominant social network in Germany has been held to have abused its market power, essentially by failing to respect data protection norms. The concern in this case, if you're looking at this from a kind of regulation competition interface perspective, is that data protection norms in the EU are really about fundamental human rights. They're protected by the Charter of Human Rights. And I think we might legitimately ask why human rights norms are delimiting the parameters of acceptable commercial behavior in this particular instance. Our third, and I think most contentious category, is where there's an antagonistic relationship between competition law and the underlying sector-specific regulation, so that competition enforcement really functions as an antidote to regulatory intervention. The first category of such cases is the least problematic, I would say. It's where we have instances of so-called regulatory gaming, namely private behavior that harnesses pro-competitive or neutral regulation and uses them for exclusionary purposes. I don't really think these cases disclose ultimately a conflict between competition law and regulation, because at the crux of the theory of harm here is the idea that the defendant is corrupting the underlying regulatory regime rather than any disagreement with regulatory decision making. And this is why these cases really seem to hinge on demonstrating anti-competitive intent. The second category of cases are a little bit more problematic. It's the use of competition enforcement to correct what we might call regulatory failures. So where there's an inadequate enforcement mechanism within the regulatory regime, where there's poor quality decision-making by the regulators, or where the regulator has just fundamentally failed to act against an ongoing market problem. To the extent that these regulatory failures are indeed creating opportunities for harmful anti-competitive behavior by defendants, I don't think there's any objection to applying competition law to those instances of anti-competitive behavior. But be careful about two things. First, the risk of double jeopardy, where the regulator is also pursuing the same conduct. And second, I think competition enforcers should have a degree of regulatory humility here. Don't just presume that there's been a regulatory failure from the fact that you, as a competition authority, looking at the problem through a competition policy lens, would have come to quite a different outcome than the regulator, which might be acting within quite a different policy landscape and pursuing different values than pure efficiency maximization or consumer welfare within the relatively narrow understanding of that concept within contemporary competition law. This brings us to our third, and I have to say, I think most problematic example of an antagonistic application of competition law. This is where the regulatory intervention might indeed be deliberately at odds with what we would consider to be good competition policy. For example, the regulator might be pursuing non-economic goals, and as a result, it sort of advocates for or puts in place a market structure that has some degree of inherent inefficiency to it. To the extent that the competition authority disagrees with that policy choice, I really think you should be very, very wary of pursuing through individual law enforcement the defendant undertaking, rather than understanding that this is a political choice, a political decision making. So I think a use of individual competition enforcement to correct instances of regulatory decision making that pursues non-competition policy compliant objectives really isn't acceptable. What the competition authority should do in those instances is engage in advocacy to explain why there might be a better way to achieve the objective, if that is indeed possible. But the use of competition law to correct these political choices really, in my opinion, seems to be really quite problematic.